Gentleman yields back. The gentleman from New York is recognized. Mr. Goldman.
Mr. Patel, does Donald Trump appear anywhere in the Epstein files?
I'm sorry, could you say that again?
It's not a complicated question. Does Donald Trump appear anywhere in the Epstein files?
I didn't say it was a complicated question. I just didn't hear you, so my apologies. We have released where President Trump's name's in the Epstein files and everybody else, and all credible information that we are legally allowed to release has been released.
All right, so let's go through that. You're referring to court orders.
The gentleman from New York is recognized. Mr. Goldman. Mr. Patel, does Donald Trump appear anywhere in the Epstein files? I'm sorry. Could you say that again? It's not a complicated question. Does Donald Trump appear anywhere in the Epstein files? I didn't say it was a complicated question. I just didn't hear you. So my apologies. We have released where President Trump's name's in the Epstein files and everybody else, and all credible information that we are illegally allowed to release has been released. All right, so let's go through that. You're referring to court orders.
From releasing grand jury testimony under Rule 6E. Is that what you're referring to when you say as the law allows?
That's a piece of it.
Really? What other evidence do those three court orders you cited prohibit from being released?
Information that was collected pursuant to those search warrants that were limited in fashion.
Wrong. That's not what the court order says, and that's not under 6E.
That prohibit you from releasing grand jury testimony under Rule 6E. Is that what you're referring to when you say, as the law allows? That's a piece of it, really. What other evidence do those three court orders you cited prohibit from being released? Now, let's take a little detour into the world of Donald Trump. Think about it. He's had Kash Patel, a staunch supporter and defense enthusiast, in his corner. This is the guy who kept saying Trump was innocent and backed his declassification stories on live TV, claiming everything at Mar-a-Lago was above board. Patel was his shield, the person who could validate that the whole classified documents investigation was just a wild goose chase. Then things took a turn when the Department of Justice decided it was time to get serious. They issued a subpoena for Patel to appear in front of the grand jury looking into those Mar-a-Lago documents.
You're not releasing those because there's a court order requiring them to be sealed? Is that your testimony?
Never said that about the videos. On the totality of the videos, of the thousands of images that were seized pursuant to the search warrants executed at the time, the overwhelming majority of that video is...
When Patel arrived, he went the Fifth Amendment route, opting to keep quiet to avoid any possible self-incrimination. So he didn't say a peep about the document's journey to Mar-a-Lago or the declassification claims. As long as he kept silent, Trump was safe since Patel couldn't turn on him. But in a twist of fate, the DOJ sought an immunity order from Judge Barl Howell. This meant that what Patel said wouldn't be used against him in any prosecution. So he'd have to testify without the safety net of the Fifth Amendment. Judge Howell agreed, making Patel testify under oath and taking away his ability to stay quiet. Talk about a plot twist. Patel was now in the witness chair, compelled to spill the secrets he had been keeping for so long. So here's the deal. Kash Patel just gave some serious testimony about what went down with the documents at Mar-a-Lago under oath. He shared everything what he and Trump publicly said about the whole declassification drama and how Trump's team handled those demands and subpoenas. It's a big deal because he was in the thick of things. And now he's revealed that Trump's claims about declassifying documents are more like fairy tales. Patel knows all the nitty-gritty details.
As I was preparing for my confirmation hearing, I had numerous discussions involving the type of people that would be employed, and that those that were failing to meet the mark at the FBI would no longer be employed if I were confirmed.
And I'm assuming that mark had to do with loyalty to the Trump administration.
No, you're wrong.
Okay. I'd like to revisit another subject from that hearing. Did you testify, excuse me, you did testify before the grand jury that President Trump had declassified the documents at issue in the Mar-a-Lago classified documents case. Is that correct?
I don't have...
He caught firsthand how those documents ended up where they did, and he can really spoil Trump's defense. He testified to the grand jury that the claims of standing declassification orders were flat-out lies. And guess what? The prosecutors got exactly what they wanted out of him. During his testimony, Patel basically turned the tables on Trump's narrative. He admitted that Trump's declassification claims were false and that insider knowledge he's got. It tears apart Trump's main defense. There's no way for Trump to shut this down or prevent the prosecutors from using Patel's testimony against him. It's all out there now on the record, ready to be used in trial. They can point to this testimony to show that Trump knew full well those documents were classified and still held on to them. And I have to say, when senators asked Patel about his testimony during his FBI director confirmation hearing, he was clearly uncomfortable. He dodged questions about what he said, hiding behind grand jury secrecy, and kept insisting he hasn't done anything wrong. But it's obvious he realizes his words could really hurt Trump. Even though he's trying to downplay the impact, the damage is done. He's given his testimony, and it's part of the official record now. It's all going to play a big role in the upcoming trial where that loyal ally's testimony is going to be thrown back at Trump, proving his defenses are falling apart. Did you testify? Excuse me. You did testify before the grand jury that President Trump had declassified the documents at issue in the Mar-a-Lago classified documents case. Is that correct? I don't have the grand jury transcript. That's why I released it. Whatever it says is the best evidence. You know, that's what you said to Senator Whitehouse, that your grand jury testimony was publicly released. It has not been. In fact, in July, a court denied a news outlet's bid to get that transcript. But the court said quite clearly that you are free to discuss your grand jury testimony. So I ask you again, did you testify before the grand jury that President Trump declassify the documents at issue in the Mar-a-Lago classified document case? And that is why I took your invitation to work with the department and the court to have that transcript released. And the transcript is the best evidence of what I said then. So here's the scoop on the classified documents case. The Department of Justice has been investigating how those documents ended up at Mar-a-Lago, and they really needed to hear from Kash Patel, who was Trump's chief of staff at the Defense Department. He was pretty much in the loop about everything concerning the document handling. So they summoned him to testify before the grand jury. But when Patel showed up, he invoked the Fifth Amendment. That means he refused to answer questions, worried that any answer could potentially hurt him in relation to the crimes being investigated. It's a smart move, since the Fifth protects him from self-incrimination, which also keeps Trump in a better position because without Patel's testimony, prosecutors miss out on some crucial inside information. But things took a turn in November of 2022 when the DOJ decided to take a different approach. They went to federal court and asked Judge Barl Howell for a use immunity order for Patel. This is a legal tactic that essentially means they can force someone to testify, and anything he says can't be used against him in any prosecution. With this immunity granted, Patel had to spill the beans. He couldn't invoke the Fifth anymore because his testimony couldn't land him in hot water. Now, why does this matter so much? Well, it changes the whole game for Trump. Patel's testimony could shed light on how the documents were handled, what claims Trump made about declassification, and the response to subpoenas, all pivotal pieces of evidence in this case. With Patel now compelled to testify, it could potentially dismantle Trump's defenses. It's honestly hard to believe how the situation has unfolded, and now we're in a spot where everything could change based on what Patel has to share. The whole situation with Kash Patel is pretty strategic and a bit wild. The goal here was more than just getting him to testify. It was about using his own words against Trump. By getting one of Trump's allies to go against him under oath, they could really shake Trump's defenses. Now, let me explain how immunity works, because it's a clever tool that prosecutors have. It comes from a federal law that allows them to make witnesses testify, even if they want to keep quiet under the Fifth Amendment. Basically, they give the witness immunity from any prosecution related to what they say. So if you're given this immunity, anything you say can't be used to get you in trouble later on. This means you can't plead the fifth anymore and have to spill the beans. However, the catch is that while it protects the witness, the testimony can still be used against other people, like the targets of the investigation. That's exactly what the Department of Justice did with Patel. They weren't looking to prosecute him for the classified document stuff. They were after Trump, so they gave Patel immunity, making him testify about Trump's actions. Before he was under oath, Patel was Trump's biggest cheerleader, going on TV to insist that Trump had a standing order to declassify any documents he took from the Oval Office. He claimed that everything at Mar-a-Lago was declassified and that Trump did nothing wrong. This public defense was building a narrative that could have helped Trump if the case went to trial, especially if the argument was that everything had been declassified. Having an insider like Patel publicly backing that story was a big deal. However, the DOJ had their doubts and thought Patel might be lying. They suspected there was no real standing order to declassify and that he was just making it up to protect Trump. So they needed him to testify under oath where lying would bring serious consequences. Plus, they could really challenge him on the record. They brought him in front of a grand jury and started asking all sorts of detailed questions. It wasn't just a simple, did Trump declassify these documents? They wanted to know exactly how the declassification process worked, what steps were followed, what documents proved it happened, who was informed, and when all of it went down. The Justice Department is really focused on getting clear answers instead of vague statements. They're digging deep to find specific facts, and if there aren't any procedures or documents to prove that declassification actually took place, that's a big issue. A former prosecutor explained that the DOJ's main goal is to have Kash Patel testify under oath so they can catch him in a contradiction with what he previously claimed publicly. They want him to admit that his statements on television were either false or stretched the truth, especially regarding any declassification order that Trump may not have followed. This tactical move by the DOJ is pretty clever because it means Trump can't rely on Patel as a witness anymore. The prosecutors have the grand jury testimony that Patel gave while being immunized, so they know exactly what he said under oath. If what he testified to clashes with his public remarks, and he admits that no declassification occurred, the prosecutors will use that to challenge his credibility. They'll show the jury that he misled the public to assist Trump, and that really undermines his role as a defense witness. Worse yet for Trump, prosecutors can leverage that immunized testimony against him in court. They could call Patel as a witness for the prosecution and insist he sticks to what he said under oath. If he tries to support Trump by changing his story, they can hit him with his own grand jury transcript, highlighting that he lied and potentially committed perjury. That would wreck his credibility and expose the claims about Trump's declassification efforts as false. We know Patel covered some important topics that the DOJ sought immunity for. His testimony included details on how documents were moved to Mar-a-Lago, the process of taking classified materials from the White House, who packed them, who transported them, and where everything was stored. This information helps establish Trump's control over those documents. Plus, he talked about the claims made by Trump and himself regarding declassification, whether those claims were true, and if proper procedures were followed. He even mentioned how Trump's team responded to requests and subpoenas related to document returns, which is crucial for understanding what happened with the National Archives and the DOJ's inquiries. So the whole situation revolves around whether Trump tried to hide classified documents from investigators, and everything we're hearing is under oath. Kash Patel could face perjury charges if he lied, so he had to stick to the truth, even if that meant acknowledging some tough facts for Trump. He admitted that the proper declassification procedures weren't followed and had to lay out the obstruction efforts, all of which creates a solid record that could be used against Trump at trial. During Patel's Senate confirmation hearing for the FBI director position back in the year 2025, it was clear he was uncomfortable. Senators grilled him about his grand jury testimony, asking what he told prosecutors, whether he contradicted Trump's declassification claims, and if he provided any evidence of obstruction. You could see him squirm. He dodged questions, saying he couldn't discuss the grand jury testimony because of secrecy rules, But here's the thing, that secrecy is meant to protect the investigation, not the witness. Generally, a witness can talk about their own testimony. Patel kept insisting he hadn't committed any crimes, mentioning it multiple times without even being prompted. That's a classic sign of someone who feels guilty and is desperate to assert their innocence. If he really testified truthfully, he wouldn't feel the need to keep repeating that he didn't commit a crime. His defensiveness suggests that his testimony likely hurt Trump, and even though he has immunity, he still seems to feel guilty about it. He even claimed he couldn't recall everything he had testified about. That's a typical evasion tactic. When someone says they don't remember what they said recently under oath about important issues, it usually means they're trying to avoid admitting something damaging, something that contradicts their public statements and could help prosecutors against the person they're loyal to. By claiming forgetfulness, Patel is trying to sidestep discussing his remarks. In the end, it looks like Patel's immune testimony has really put a dent in Trump's case. If his testimony had actually supported Trump, he would be eager to talk about it, explaining how he defended Trump under oath, confirmed declassification, and disproved any claims of obstruction. But instead, he's avoiding the issue, hiding behind claims of secrecy and poor memory while insisting he didn't commit any crimes. This all points to the fact that his testimony ended up being damaging for Trump. So, here's the scoop. Kash Patel is in quite the predicament, and he knows it. This whole situation is really a part of a strategy the Department of Justice has been using lately. They're flipping insiders from Trump's circle by offering them immunity. Just think about it. They granted immunity to Alan Weiselberg, who was the CFO of the Trump Organization, and that pushed him to testify about some financial crimes. They've done the same for Trump's lawyers to get them to share what they know about legal advice. And even the staff at Mar-a-Lago had to spill the beans on how documents were stored. It's a smart move using immunity to get loyal witnesses to provide evidence against Trump, building a case with information from his own team. Now Trump's in a tough spot. There's nothing he can do to stop this process. He can't block the testimony that's been granted immunity. The whole thing about attorney-client privilege doesn't hold up when it comes to crimes and fraud. Immunity trumps that. And he can't hide behind executive privilege either, since it doesn't cover criminal activity. Plus, any intimidation attempts he might consider won't work because the immunity protects those witnesses from being prosecuted. So, Trump can only sit back and watch as prosecutors methodically flip his inner circle thanks to these immunity deals. Let's dig a bit deeper into what's going on with Patel's testimony, because this is really a significant blow to Trump's defense over the classified documents issue, and there's not much Trump can do about it. Initially, Patel was using the Fifth Amendment to avoid talking to the grand jury about those Mar-a-Lago documents. The DOJ had subpoenaed him as they were looking into classified documents, and being Trump's former chief of staff at the Defense Department, he knew exactly what was going on with the handling of those documents. But by claiming the Fifth Amendment, he was keeping quiet to protect himself and